The next segment we're going to begin with is hot topics. So welcome again. Thank you for everyone for coming. My name is Michelle Sheehan. I'm a judge on the 8th District Court of Appeals as well. So for the hot topics, we thought, what are the topics that you should know, but you might not know? And we tried to cram as much as we could into one little segment. So we're going to talk about 3 hot topics that you may know, you may not know, but we're just going to identify them so you know they're out there and you know about them. And then the last segment is going to talk about self-defense, that ever-changing law that there's really no law, but we're going to we're going to try to, from a practical approach, give you both sides on how to approach those types of cases. So we're going to start with the first topic of, you think you got a final opinion from the Court of Appeals, can it be reconsidered sua sponte? And today we have with us Jim McGlone. He's a former judicial attorney, and he's currently the en banc lawyer at the 8th District Court of Appeals. So with that, take it away, Jim.
Thank you, Judge Dan. I think this is the second year in a row I've had to follow Judge Sean Gallagher. So
it's painful.
You did find my booking agent here. So our first topic is just a bit of an appetizer, and this deals with the ability of the Court of Appeals to issue sua sponte reconsidered opinions. So I'm sure most of you are familiar with the ability of the court to issue a recon while the case still hasn't been appealed to the Ohio Supreme Court during that 45-day period, which is the most traditional sort of recon that you're familiar with. But the Ohio Supreme Court gave us a very interesting case. The only time they've really touched on some unique circumstances where the court can issue recons. That's the LTV Steele versus Gwynn decision in 1992. And effectively, what they established there is that while you have a timely filed motion for reconsideration, or a motion for en banc consideration, or even, I believe, a certified conflict pending in front of the Court of Appeals, the court still retains jurisdiction while those motions are active to issue a recon. So a lot of times we'll see instances where an en banc is filed, and in order to avoid a conflict, we'll issue a recon instead, which is much easier and more simplistic to do than a full en banc opinion. And this can even happen when you filed a motion for reconsideration and the panel originally denies it. If the court a month or two later realizes, hey, maybe there really is a broader intradistrict conflict here, we still have the ability to issue a recon opinion. So I know that that's something that surprised litigants in the past, but under the OC's decision in LTV Steele, the court basically can order a recon anytime these post-judgment motions are timely pending in front of us. So it's just something to keep in mind. If you file an en banc motion, you're not necessarily going to get an en banc opinion. If you might get a sua sponte reconsidered decision instead, that sort of resolves the issue one way or the other.
But what if the appeal, they've also filed an appeal to the Ohio Supreme Court? Can we still do anything?
That's more of a gray area, and I wish that the most recent decision was in 1992. It would be nice if they'd give us some more guidance. I know that traditionally the court waits for us to resolve these motions before they take any action, such as indicating they're going to accept jurisdiction on most of these cases.
Has this happened to anybody where they all of a sudden got a motion for reconsideration or an opinion reconsidered? I'm just curious if it happened to anyone. It has? Lou? Okay.
It's pretty common.
Okay.
So with that, I'll turn it over to Samantha, who's going to tell us about Tate orders.
So before she jumps into Tate, we got to tell you, Samantha Madden, if you haven't met her, is also she's a judicial attorney at the 8th District Court of Appeals, and she was at the 11th District as well, and currently works with Judge Forbes. So with that, what's a Tate order?
Okay. So a Tate order, we'll start with what the Supreme Court has said. Okay. So, appellate court should not decide cases on the basis of a new, unbriefed issue without giving the parties notice of its intention and the opportunity to brief the issue. So, what does that mean? During the review process, the appellate court might notice something. Something might just, catch their attention that wasn't raised by the parties. Pursuant to Tate, the court isn't permitted to decide that case on that issue without first giving the parties the opportunity to brief it. And so they might issue a Tate order specifying what that issue is and what they'd like to know about it. Here, it might be hard to read, but you'll get it in your slides. There are a couple of different examples of Tate orders, but just the one thing I wanted to say about them was that they might come in different forms at different times, and they might ask for different things. So you will be required to brief it for the Supreme Court's decision. But in one of the examples, it directed the parties that they should be prepared to discuss a certain case or a certain issue at oral argument. So it said, hey, we're going to request the briefing, but when you come in to argue, we want to be ready to talk about it. It also might come after oral argument. Maybe oral argument went a certain way and it, drummed up a new idea that wasn't initially addressed by the parties in their initial briefing, but the panel wants to know a little bit more about it because they think that it might be dispositive.
So turning to the application of Tate orders, we can't emphasize enough how seriously you should take them if you get one. Panels are generally loath to issue orders for additional briefing once a case has already been fully briefed. So if you receive a Tate order, in your case, it's generally because the panel is looking at some issue that they think is dispositive of the appeal. Or at least potentially dispositive. So it should be a flashing red light that you're going to want to pay attention to and treat it as if the outcome of your appeal turns on the resolution of the issue when you're briefing it. Again, what to do if you receive one, as I said, take it very seriously. You're going to want to make sure that if you feel that the issue is not dispositive in the case, you explain in great detail why it's not controlling. Conversely, if you think it favors your client and you could get a favorable outcome depending on how we apply it, you're going to want to make every possible argument you can, to protect your client's interests on this issue, because the panels really only issue these when they feel that there's a significant issue here that needs to be looked into. So take them very seriously. I've seen instances where litigants almost ignore it or really sort of give short shrift on the briefing. So you want to take them very seriously.
Is there a show of hands who's received a Tate order? And of course, Liv. And how was it handled? Was it before argument or after?
I got mine after. The lead Judge Jones was really interested in how the Second Amendment could apply. It was a concealed weapon and tampering case, and actually Dan Van and I went against each other on this, and so we both were kind of like, how could the Second Amendment possibly apply to this case? Briefed it, and then it came out ruling was reversal on sufficiency. So
did you ask for more argument on it, or was that not an issue?
No,
Okay.
we did. We talked about it in argument already. So I guess, and they asked for simultaneous briefing. So I figured they were just ready to issue a decision pretty quick after it. I just went with it.
Okay. And Erica, you said you have?
Court wanted a sufficiency argument from the parties rather than a waive. So I gave.
So it wasn't initially in the briefing. Okay.
Right.
And how was the outcome? Was it? The Tate orders can be good. Just take them very seriously. It depends. Okay, the next topic is expungements and sealing the records. We all know the statute keeps changing. The legislature keeps doing things with that. So today we have Candace Wahab, excuse me. I had that down earlier. Also a judicial attorney at the Court of Appeals, and she works with Judge Frank Celebrezze. She's just going to give you the highlights of what you need to know.
Okay, so thank you. As Judge Sheehan said, I'm going to talk about the difference between expungements and sealing of records. This is fairly new. The statute was amended this past April. There were sweeping changes that I could probably fill a whole CL even talking about, but I'll spare you and spend 3 minutes. The major distinction, the first one, is the fact that an expungement is now a real thing. Previously, under Ohio law, they were used interchangeably. The expungement is brand new. The sealed record was a record that was removed from public record, but it's still maintained and it might be accessible by parties like the BCI, certain statutory parties. We now have the expungement, which is it is destroyed, deleted, or erased as appropriate based on whether it's physical or electronic, such that the record is now permanently irretrievable. So we have 2 different remedies under the law now, which is important. The main difference between them is the waiting period before you can apply. So for example, to seal a felony 4, you need to wait a year. To expunge one, you need to wait 10 years. So that's a pretty significant difference, but they can be applied for at the same time. The application is the same and the substance of the tests are the same. Which brings me to the major point number 2, and that's what tests should the court apply here? Under the old iteration of the statute, there were 2 prongs. It was, is the offense eligible? And then is the offender an eligible offender? Eligible offender was a statutory term, and it was reviewed de novo on appeal because there were certain factors like prior offenses, things like that that were all set out in the statute. That has been completely eliminated. So it's now probably easier to get an expungement, but it is definitely more discretionary. So now there is a 6-ish factor test that the courts are going to look at. And they're required to balance things such as, are there pending charges against the offender? Does the court think they've been rehabilitated? Has the prosecution filed an objection? Has the victim filed an objection or appeared or expressed their opinion? It's a general weighing of whether the government's interest in maintaining the record outweighs the interest of the offender in having the record sealed. So that's probably going to be a major difference. Is instead of a de novo review of who's eligible, we now have a discretionary test that puts it in the hands of the trial court.
So now it's abuse of discretion.
Yes. And back to the eligible offenses, that hasn't changed too much, but there are 2 offenses that were available to be sealed or expunged under the previous statute that are no longer. And that's M4 domestic violence and violation of protection order. So now domestic violence charges, no matter what, cannot be sealed or expunged. And same with violation of a protection order. Third and final point about major change under the new legislation is there's not time constraints. So when the application was filed, it was sort of just whenever it was set for hearing, and that's all. That's changed. It must now be heard within 45 to 90 days. And after the hearing is set, the prosecution has 30 days to file objections to that. And there's also significant requirements for notifying the victim under Marcy's law. I won't get into Marcy's law.
Just don't. Go ahead.
Those time constraints, is that shall or should?
Doesn't matter. And I will, even though it's abuse of discretion, I've seen a few recent cases that people are still raising it on appeal, and some are getting reversed, some aren't. So as a practitioner, it's still bubbling up. And by all means, ask questions. Both panels encourage it. So if there's any other questions for these 3, we're going to move to the next topic, which is self-defense. Yes.
I guess this would be for Candace. So I've noticed that I've been looking at this recently, it confused me. The newly revised sealing and expungement statutes do still use the term eligible offender, but there just isn't a definition for it anymore.
Right.
So I've been confused about what to make of that.
So eligible offender, it used to be like this convoluted, it was like 2 paragraphs designed, and now it's no longer you're an eligible offender. It's the trial court's going to holistically look at you on a case-by-case basis and determine based on the factors that I said whether you're an eligible offender.
So I guess you did sort of, all right. Sorry.
Probably better for the defendant, the new statute. Okay, well, thank you, everyone. We're gonna, one more question, yeah.
Is there any mechanism in the statute that talks about how you go about expunging a record after it's been sealed?
Oh, I don't know about that.
Are you paying attention now, Bird? Okay. Oh, go ahead, Larry.
Question. Back in the 90s, there were numerous instances of people who didn't have a conviction out of a state court, but had a federal conviction for something, were then filing pro se requests with the Court of Common Pleas to obtain a sealing of the criminal record.
The criminal record in federal court, right?
They were being granted by the Common Pleas courts.
I think it's still going on today. I think people are still filing in state court to seal criminal records, and I think some have been successful. Don't quote me on that. Yeah. No, what? They're not, oh, but I've tangentially have heard it's going on. Judge Mays, did you have your hand up? No? Okay. Any other questions? Because we're gonna move on to yeah.
My manager and Greg are whispering the answer in my ear.
Oh, perfect. Yes, yes. Thank you.
Can't hear.
Okay.
Oh, sorry. So I'm gonna introduce, but she's actually my criminal manager, Crystal Lawyer, who also knows most answers that I don't.
Perfect.
Okay, so the question was in our common pleas court, how we handle a case that's been sealed but then now filed for expungement. So we only accept those in person, not through an electronic filing system. And they have to file it in person in our office. We temporarily unseal that record, file it, and immediately reseal it back. And a hard copy is sent up to the courts so that they can process it.
That answer your question, Erica?
And that would be filed on the second floor of the clerk's office. You don't have to ask for me.
And clearly don't ask for me.
Wait, there's a follow-up.
The attorney do it or must the?
Wait, for the
actual-
Zoom people, we need to get you a microphone.
Can the attorney do it or must the actual individual walk in?
So we can have it for.
Wait, Zoom.
You can talk loud enough.
No, Zoom.
No. We accept them from either the pro se litigant or the attorney. It doesn't matter. We allow it either way.
Perfect. Thank you. Okay. Okay, with that said, thank you. You're welcome to leave the stage, and we'll have our next three to talk about self-defense. And the problem we encountered with the self-defense law has recently changed, as all of you know, but there hasn't been a lot of case law bubbling up. And we as a court didn't feel comfortable saying what we thought or, wouldn't want to give an advisory opinion. So there is a little bit of case law, and Amanda's going to talk a little bit about what the law was and what the law is. So Amanda Stevens is also a judicial attorney at the 8th District Court of Appeals. She works with Judge Boyle. And then we're going to go to the experts and talk. We're going to give you a scenario, and we'll talk a little bit about how both the prosecutor and the defense might handle a specific fact pattern on self-defense. So before I introduce the remaining speakers, Amanda, why don't you tell us what the law is on self-defense?
Sure, thank you, Judge Sheehan. Here we go. All right, so House Bill 228 amended revised code 2901.05, statute governing self-defense. House Bill 228 became effective on March 28th, 2019. Prior to that date, a defendant claiming the affirmative defense of self-defense had the burden of proving the elements of self-defense by preponderance of the evidence. But the 2019 amendment shifted the burden of proof in a self-defense case from the defendant to the prosecution. If there is evidence presented by the defense that tends to support that a defendant acted in self-defense, the prosecution must prove beyond a reasonable doubt that the defendant did not act in self-defense. According to the Ohio Supreme Court decision State v. Brooks, the amendment is not retroactive. It applies prospectively to all trials occurring after the effective date, regardless of when the underlying alleged criminal conduct occurred. Maybe. There we go. All right. So the very tiny red lettering in this slide.
It's all in your materials.
Yeah. Indicates all of the changes made by the 2019 amendment. I want to quickly highlight State v. Messenger. It's included later in the materials, along with State v. Brooks and two other pending Ohio Supreme Court cases that you may want to keep an eye on. In Messenger, the court clarified that the 2019 amendment did not transform the absence of self-defense into an essential element of a criminal offense, and that self-defense very much remains an affirmative defense. The Messenger court explained that a defendant has the burden of producing legally sufficient evidence of self-defense to trigger the state's duty to overcome that evidence. Messenger also held that the state's burden of disproving the defendant's self-defense claim beyond a reasonable doubt is subject to a manifest weight review on appeal. On a procedural note, you'll also want to pay really close attention to Criminal Rule 12.2,
which was added in response to all these changes in red. We'll be discussing terminal rule 12.2 in a more practical sense in a little bit, but the rule requires that a defendant file notice of their intent to offer evidence or argue self-defense. Otherwise, the court may exclude the evidence. The notice must be filed at least 30 days before trial in felony cases and 14 days before trial in misdemeanor cases. You also want to check out the rule before you file the notice because it requires certain information be included, like specific information regarding prior instances or circumstances related to the conduct of the alleged victim and the names and addresses of witnesses. All right, so there have also been some big changes to revised code 2901.09, amended by Senate Bill 175. That amendment became effective on April 6th of 2021. The prior version of the statute provided certain circumstances in which a person had no duty to retreat. For example, when a person was lawfully in their residence or was lawfully an occupant of their vehicle or a vehicle owned by an immediate family member. But the 2021 amendment eliminated the duty to retreat before using self-defense so long as the person was in a place that they had a lawful right to be. The amendment also eliminated the trier of fact's ability to consider the duty to retreat. Slideshow just does not want to go forward.
I used to write out.
Yeah, I'm using one. Oh, okay, more information, and we're gonna go to the next slide. All right. So in addition to the pending Ohio Supreme Court cases mentioned later in the materials, you also want to keep an eye out for this piece of proposed legislation. House Bill 233 seeks to amend revised code 2901.05. The bill creates a pretrial procedure for a person asserting self-defense. The bill was introduced in June, referred to the House's Criminal Justice Committee in September, and the first hearing was on November 14th, just a couple days ago. All right. And now on to the answer.
Okay, so that was a lot, and there's a lot of words there that I'm sure are going to be disputed as we go along. So we thought, okay, what are some of the major issues you really want to be aware of when you might have a self-defense issue in a case? So we went to the experts, and in one corner we have Sal Awadallah from the prosecutor's office. I hope I got that right. Most people know Sal. He's been around almost 30 years. He's been in every division. I think you were the supervisor of the major trial unit. He is the chair of the self-defense committee. Sal could stand up here and talk to you for probably 5 hours on self-defense, and we're going to limit him to 20. But more importantly, he's our only case graduate on this entire panel. That's okay. On the other side, we have Rob McCaleb. He was also a judicial attorney, worked in the civil world, and is a public defender in the criminal world. And we see him almost weekly, monthly. He's in the Court of Appeals a lot. So unlike Judge Sean Gallagher, who didn't give you a warning, I'm going to give you a warning. We're about to show a video. It can be disturbing. You do not have to watch the video, but it sets the stage for a case. It's not a real case as far as we know. It came off of YouTube, but it involves a road rage incident between two strangers. So I'm going to lean on Sal or Rob to skip 2 slides and go to the video, and we'll play that and we'll talk a minute and go back to these in a second. We'll just play it out first and then we'll talk. Okay, you can, we don't need to keep seeing it, thanks. So, but you want to go back 2 slides to the law. As you can see, road rage incident between 2 strangers, and for purposes of the discussion today, assume there's 3 shots. The 3rd shot is the shot that actually kills. So with that scenario, we'd like to hear from both sides, how do you approach this case? Who wants to begin?
Well, thank you very much. Bring to this panel. So we just saw there in the scenario, you know, as appellate attorneys, you often see the case afterwards, and you see the record. We're going to ask you now to put yourselves in the place of folks who are going to be at the very front end of the decision-making process and making decisions as to what charges should apply and whether self-defense apply or not to the scenario. There's some practical issues when you're in trial with regards to jury instructions, what jury instructions you ask for in your request with regards to the scene. So everybody we went through it pretty quickly there.
Feel free to raise your hand and ask questions, but
You want to see the video again?
you need to see the video again? Okay.
Is there a way for somebody to tell us who's who in the video as it's playing?
Yeah, so let me
Okay.
see real quick. So this is actually an actual case, but it's not it's an actual incident, but it's not one of our cases. It's kind of written off somewhere. But you can see it's a
Yeah, the video.
yeah, it's a road rage incident. The gentleman with the stick has now followed with the vehicle to the parking lot. The white vehicle parks. The gentleman in the black vehicle gets out. Does he retrieve a deadly weapon in this case? What is his motivations here? Is he applying deadly force? You see this gentleman. Yeah. So you see him. You see the gentleman, the driver in the car. He first gets out, but then he goes back in. If you notice, he then reaches for his gun and racks his gun. All right. So 3 shots. All right. Last few, first shot, second shot, and 3rd shot. Which one of those are self-defense? Are they all self-defense? Once you start shooting, are they all self-defense? Or does he cross the line in his defense at some point? So, yeah. Is that clear? So let's watch the video. You know, I was very nervous about Joey's video, but after seeing the Trump video. So here's again, they've gotten into some sort of skirmish on the road. Black car there is going to pull out perhaps a deadly weapon. And watch him go back in. Now he's a castle doctrine, and he's in his vehicle. Yes. 1 shot, 2 shot. Now here's the coup de grace. It's the one over the top. And our pathologist will tell us the one over the top is a fatal shot. Okay. So with that, that's the scenario. And we'll ask you what you think in terms of is this self-defense all the way through? Is it self-defense at some point? Does it cross the line?
Yeah, so one of the things we talked about is this video does this video alone tend to support the self-defense claim? Like is that kind of enough? We don't really know what tend to support means yet. I think we'll probably learn soon. So we know from State versus Messenger, as was mentioned earlier, that self-defense is not an element of defense. It still gets the constitutional burden of proof for elements of the offense, that is to say beyond a reasonable doubt, but it's not an element. So what do you have to show? It tends to support what? Every element of self-defense, some of them, a preponderance of them. It's not really clear. The Ohio Supreme Court has a pending case. We were really hoping it would be decided by today. It was argued in September. It's in our materials. It's called State versus Palmer, and that will hopefully answer whether it is evidence of every element or something different. Again, we don't know what tends to support means. I think, from the defense perspective, regardless of whether it's required for every element or preponderance of the elements or only one of the elements, whatever it is, it can't be more than enough to create a reasonable doubt in the mind of a rational fact finder, right? Because if it does that, then the government has failed to prove that it wasn't self-defense beyond a reasonable doubt. So to me, that means something like less than a preponderance and more than a peppercorn, to use contract law terms, more than just a tiny little bit, but less than a preponderance. And that's just, again, to get the instruction, to get the jury instruction. So again, I don't want to predict exactly what the court will say in Palmer, but I think it's going to be something like that, less than the preponderance, more than nothing. And whether it's every element or not, I think we'll find out soon.
So in the defendant had burden of production, yet to show that there was, an element of self-defense, almost like the other case, fellas, you kind of know when you see it. And a lot of times you have these cases on video, you'll think that, even though you still will have, different opinions as to what it is. But the defendant always had a burden of production. They always had to show that there was an element of self-defense. And then in the past, they also then had a burden to prove by the preponderance of the evidence that it was self-defense. So as a prosecutor, you would just prove the elements. Did he purposely cause the death of this person? I'm done. Okay. And then I sit back, and then the defendant would have to get up and then prove by preponderance of the evidence that it was self-defense. And there's three elements of self-defense. The changes, as Amanda's pointed out, now there's still a burden of production. And that's what Messenger really kind of thought. There's still a burden of production. Then it shifts. And when does it shift? Only when the defendant has met his burden of production to show that there's some sense that there's self-defense here. And then when that shifts, then now it's up to the state not only to prove that he purposely caused the death of somebody, but now I have to prove negatives that he wasn't that the defendant was did start to afraid that what he did wasn't reasonable. He didn't have a reasonable fear for serious bodily harm and or death, and that he his actual words were not proportional. So I have to prove that by beyond a reasonable doubt on three negatives in order to, well, at least one negative in order to stop that self-defense in its tracks.
And who decides that the burden has been met and it now shifts and the state has to? Is it the judge or is it the jury?
Well, that's kind of what Palmer's all about, right?
Palmer and Messenger will give us a lot of information about that. Messenger, especially Palmer's, but so or Messenger's already out. Palmer's will wait for. So the question is, I think this is a more or less exact quote from the memorandum of support of jurisdiction. This is the question that the court accepted: is does a trial court improperly shift the burden of production from the state to the defendant, where it first requires the defendant to present qualitative evidence proving each element of self-defense? So it's ultimately the judge is deciding whether or not to give that instruction. But the question really is like, how much does the defendant actually have to show?
Will this bill pending, will that help things? Because as I appreciate it, that bill says the defendant can file something with the court to say, court, tell us in advance if I'm going to get the instruction.
Yeah, I mean, we'll see if it passes and then what indeed it does. And I mean, it seems to me like the sort of thing that obviously, I mean, every case is different. It strikes me as the sort of thing that would be helpful to just know in advance. There are some, and we'll talk a little bit about 12.2 and at least the defense perspective on some of that. I think there could potentially be some issues in terms of attorney work product, attorney client privilege, right to remain silent, things like that, with those notifications that law does pass. But on the other hand, it might give everybody a little more clarity just on the outset. Because I mean, it in a way, it kind of sucks to, I mean, obviously, if you are operating on the assumption that you're going to get self-defense instructions, you're asking, you're cross-examining on that, you're presenting evidence on that, and then you don't get that instruction, that can obviously be.
It probably happens more than you think. So
I mean, I've seen it happen just in my appellate work. I've seen it happen in as an appellate, I mean, helping our felony attorneys are prepared for and argue jury instructions is, the whole case is based on self-defense, and then we don't take instructions.
So what's the next big issue when we look at this video that have we talked about charging and then how it's gonna play out?
Yeah, so in this case, we have self-defense, maybe. Who thinks self-defense for the first shot? Guys in the car, guys coming at him. Who doesn't think it's self-defense for the first shot? How about the second shot? Who thinks it's self-defense? Now, those two are not fatal. Okay, now you have a client who's charged with murder because he's killed the gentleman. Who thinks the third shot is self-defense?
Of course Lou does.
No. So why? Why would the third shot? Why would the continuation of the shot? What's happening that would change a self-defense shot to a not self?
Professor Paula says he's hand up.
Sure, I don't come out that, I'm sorry.
Wait for the microphone.
I
Wait for the
was just
microphone.
thinking- Excuse me, I was just thinking that, we hear all the time, for example, in qualified immunity cases where police officers are either charged or sued for excessive force. And the notion is that they have to make snap decisions without the ability to process and so forth. That's what this feels like. It feels like a snap decision that then carried on maybe longer than necessary if you look at it objectively. But I don't know that the person in question, after being almost hit in the head with that stick, has the presence of mind to appreciate when it is no longer reasonably necessary to use force.
Very good. So I'm sorry, go ahead.
Oh, I was just gonna say that my at least understanding its conception of deadly force is that you have the right to shoot to kill. So I don't understand why defendants would be required to stop shooting before they've killed in instances that are valid self-defense. And I know that there are states.
There's a reasonableness factor.
Sure, and that largely is going to turn into a fact question for jurors. On appellate review, it's tougher, obviously, but there are definitely courts that briefed this issue recently, and certainly in Georgia courts, if you're there, they have been very clear that you get to shoot to kill. So I think that's interesting.
Shoot to kill, but without something that's changed. So what's changed in this case? Somebody's intervening, and the guy's already been shot twice. So I'm just playing devil's advocate. So
Sure.
That's changed, right? Who thinks? So here's the question, because we only have about 10 minutes. So we have murder, and also there also be another affirmative defense, and that's voluntary manslaughter. So voluntary manslaughter, then, and that may be a choice that maybe as a practitioner, as a counselor, you have to make. Is it, do I ask for a self-defense instruction, or do I ask for a voluntary manslaughter instruction? Because at least in the 8th district here, you can't ask for both. As a matter of strategy here, what would you choose? What, based on this fact pattern?
Just as a prosecutor, if that's your scenario, are you charging one count of murder? Or would you try to charge one count for each shot?
Yeah, I'm not answering that question. You gotta.
Come on.
Make too many decisions like this.
Another question down here.
What would you do? What would you do? Yeah. Sorry, what would you do?
I'm on the other side, but to be safe, cover my hedge my bets. I'd probably charge the 3 counts each shot potentially.
So you charge murder.
Maybe.
Do we know how the door to the car is opened? Does the person wielding the gun open the door, or is it pulled open by our 2x4 wielder?
The guy steps out, and the door actually locks and pushes it, right? And then he is back in the car, reaches for it in the middle of counsel, reaches for the gun, racks it, and then comes back out, then shoots while he's in the car. Remember, Catholic doctrine in Ohio, it's not just about your home, your business proposals, applies to your vehicle.
Yeah, no, I just think that it turns on he was locked behind that door theoretically if he chose to engage. That seems like it's the most relevant fact to me.
Well, here's it again. What would you charge?
I would definitely. I don't think it's self-defense when he chose to come out of the car.
Tony down here at the state.
But I was wondering if the issue is whether there's legally sufficient evidence to get to the self-defense. I mean, if you have to assume that look at the evidence in light most favorable to the fact that this would be a self-defense, this could be self-defense, if you're looking at it from that perspective, the fact that we're debating this to me makes it seem to me that you would have sufficient evidence to get the self-defense instruction.
Yeah, I think that's a really important point. It's like a lot of this, you know, these are ultimately going to be there's very little like clear black letter law where there's a case that says, you know, this is what's going on, this is what happens. These are all going to ultimately be jury questions, really, pretty much all of this. And so even like reasonable force, like Lou, you know, I don't know. I mean, even as a defense attorney, I'm inclined to think once you shot the guy twice and he is falling towards the ground, you probably that third shot, if that's the one that kills him, it's probably murder. Right, because at this point you don't have a reasonable and honest belief that you are at imminent risk of serious or grievous physical harm or
It's
death.
possible a jury could say no.
But it's possible a jury could say no. And so, you know, in a lot of this, I mean, I think it's really important to think carefully through what you're doing in these cases and why. And, you know, so if like here, like Sal mentioned reasonable force. And the OJI actually includes in the deadly force self-defense instruction something that says, you know, and it has to be, it can't be unreasonably excessive, the use of force. Now, obviously, there's cases, you know, if you're getting mugged and you like call in a drone strike, that probably and you've probably done other crimes as well, right? If you're like leveling in city bodies, that's not usually what happens, right? Usually someone's getting mugged, so they take out their own gun and they shoot the guy. Okay. And so, you know, I'm not saying you have to do this in every case. It would probably be inappropriate in every case, but something you might want to consider is objecting to that additional instruction about no unreasonably excessive force. And here's why. One, if you're in a situation where you can use deadly force, which is to say you have a reasonable and honest belief that you are about to be killed or grievously physically harmed, then you can kill the guy. As you suggested, like you don't have to wait to be shot at first. You don't have to shoot to scare or shoot to wound. And that instruction, I think, you know, potentially creates a risk of suggesting to the jury, hey, maybe he did, maybe you could have shot him in the leg. Maybe you could have shot one in the air first. Maybe that would end the month. That's not the law. Okay, if you honestly and reasonably believe that you were about to be killed, which I don't know if this guy did. I mean, it looks like a stick. Maybe it's a PVC pipe. It could be a pool noodle. You know, that's a there is it's not that you want to object in every single case of that instruction. It's that you want to think, should I object to this? Do I want to have this fight or not? You know, it depends on the case.
So we're now at the end of the case, and you got a decision to make. If you ask for voluntary manslaughter, you take a life tail murder count down to 3 to 11. Right? You have a chance at short period, dramatically shortening your client's sentence if he's found guilty. Or you go for it all and ask for the self-defense instruction. Thinking that the jury's going to, buy the proposition that you shoot once or you shoot 3 times, they're all self-defense because they all happen in such a good sequence. So who's opting for the voluntary manslaughter instruction at the end? But you wanted to.
That's a good question.
Nothing for self-defense. My guy came at me with a deadly weapon. If that door wasn't in the way, he would take my head off. You saw I'm in my car. I got presumption of self-defense because it's in my car. And I did what I had to do in order to stop that threat. Did I convince anybody to go for the self-defense?
Depends on my attorney. Depends on how good they are.
Well, those are the considerations as practitioners that you're gonna have. And then there's probably
We're actually at the end of the time. There's like 30 seconds. Is there any burning questions anybody has for this panel before we end? Okay, well, there's your issues. Everything's in the materials and oh, wait, one last, yes.
Microphones.
No, I'll have to say. Oh.
Well, they did.
It looks like they did.
Today? Yes. It looks like the Supreme Court decided State versus Palmer on the 15th of November. We don't know. We have to update our materials.
Yeah. I have one last question if you have moments off. So in an instance, you mentioned that they only have to be in fear if there's an escalating incident between two people and one person pulls a gun. That's it, even if they themselves think that they're protecting themselves from whatever the last escalation was. At the point that someone pulls out a gun, the other person can whip their gun on, shoot faster, and it's just sort of like who's the last to act. Is that how the law is?
Well, so you can't be at fault in creating a situation.
Okay.
So I mean, so that's, so I think, you know, if you go and put something in the forehead, that's, you know, and then they're trying to keep you in the chin, and then it escalates back and forth until they're shooting at each other. You know, if you're the one who started that, I don't think that you can. Right. So it's important that you.
There's an 8th district case on that.
And that's the first element.
Get to you later. Okay. Well, thank you very much, everybody. We'll be around at the end.